You have been
I don't
arguing in the
know.
past on my shows that they had done their 15 years. The fact is, Mr. Malhotra, they may have done their 15 years, but they had repeatedly got parole. They were extremely powerful and influential. They were obviously people who had connections with the government in Gujarat, and it would seem that the Union Home Ministry also concurred with the Gujarat government on them. The crime itself was as heinous as it can get. Gang rape and murder. Cold-blooded murder. Now, can that be, Mr. Malhotra, reason enough to give remission in such cases?
You see, please do not forget, even today's judgment of Supreme Court has recognized that they have a right of remission. Only thing which they have varied is that instead of approaching the Gujarat government, they need to approach the Maharashtra government. So remission has never been snatched by either of the Supreme Court judgment, number one. And I have been telling in your channel and again different channels that once the policy stipulates, which is a 92 policy at that time in Gujarat, which stipulates that for consideration of remission, there are twin conditions. One is they must serve actual 14 years and they must have a good conduct in the jail. So post jail conduct, if they have been garlanded or if they have been victorious enough to show the signs and all that, that is not the material for consideration for remission. If they have a good conduct, which the jail authorities have certified in this case, all the files are before the Supreme Court, all the original data was before the Supreme Court, they have been granted good conduct by jail authorities for overall 15 years. That was the requirement under the 92 policy. And therefore I said, once the Supreme Court has held in 2022 that a policy of Gujarat has to be applied, today we have two judgments now of Supreme Court, one saying Maharashtra, one saying Gujarat. Supreme Court say that...
Yes, but Mr. Malhotra, Mr. Malhotra, look at the way the Gujarat government then goes ahead and sets up a committee consisting of BJP MLAs, consisting of BJP members. When you know that many of these,
Just a minute.
Many of these MLAs have links to the are alleged. No,
just a minute. That's only
a 10-member committee, Mr. Malhotra, is set up. That committee. No. The fact is, when a committee is set up to look at remission, it should be an independent committee. It should be an independent committee. It should not be a committee which already has a preconceived notion that these are sanskari Brahmins. I mean, that's the problem. You can't have a committee which is, it almost seems as if the entire process is rigged. Neeraj Chadda Borvankar, you asked the question, why should they have been granted remission? My point is, everyone is entitled to apply for remission. It's the manner in which government committees are set up to either slant the verdict one way or the other, which is where my problem is. Would you agree with that?
No, let me interject. Just see the judgment of 280 odd pages, not a single line on this aspect at all casted by Supreme Court. It's all media speculation that MLAs and advisory committee consist of partition stakeholders. Not a single line doubted by Supreme Court in its entire judgment today.
Okay, so I am raising that question. The Supreme Court has called it just a minute, sir. Supreme Court has called it an act of fraud. Right, but Neeraj Chadda Borvankar, is that part of the problem? That the state itself could be hugely partisan in cases like this, and that's why public confidence and faith in the law is diminished.
Absolutely. So states, instead of following the rule of law, are being out and out doing favoritism. As we can see in the over-enthusiastic response of the state of Gujarat. But my point is that a convict may have and indeed has a right to seek remission. But the government, while granting remission, should appreciate the gravity of the offense, which I feel in this particular case was so heinous, so serious, so grave, that remission should not have been granted one. And if 1992 policy of Gujarat says that remission can be granted in such cases also, then the policy needs to be thrown away. New policy should be drafted Otherwise, women are definitely not safe. And if Delhi gives death penalty in Nirbhaya case, then why we are being so soft in this particular case? That is also my question.
Well, that is a question that obviously is a question that should haunt many people out there. Premila Nasargi, let me give you a comment there. Would you agree with what Miran Chadda Borwankar said? When there is public fury and people say Nirbhaya's killer and Nirbhaya's rapists and killers must get death penalty, and that's what they get because the entire country is agitated. But it doesn't happen with Bilkis Bano, a hapless woman in a village of Gujarat. Would you agree that the law must be the same for all? Every Indian has equal right. It cannot be that a gang rape in Delhi results in the death penalty, but one in Gujarat does not.
I agree with you. What we want is justice according to law.
Mr.
You can't go in a highway. We are not in the banana republic. We have a law and rule and regulations. We are bound by it. We are bound by the rules framed. If you are aggrieved by the rules, ask the parliament to change the rules. Ask the state government to change the rules. So long as the rules are there, so long as the Gujarat government has got the power of remission, so long as the rule stays, unless it's changed, they have to act according to law. We see, the criminal jurisprudence, we have a reformative theory and also retributive theory. Which you want? Don't you want your citizens to reform? You do not want them to reform in the society?
So you're going to garland convicts?
As criminals only?
So reform, so you reform society, Miss Nesargi, just a minute. Miss Nesargi, no one reforms society by garlanding rape convicts. A society doesn't get reformed by garlanding rape convicts. Let's be very clear about that. There is no place in a civilized society for rape convicts and murderers to be garlanded because they are politically aligned.
Every day we see
I hope you recognize that and appreciate what I'm saying.
Who are arrested and they are brought out. They are doing it. You see that. See, the law must be. You make a law. The convicts who come out of the jail should not be garlanded. It should be treated as an offence. It is not material.
Okay.
You tell them. The family members, the kith and kin, friends, they just want to garland. Who are you to prevent it? Who are you to prevent it? Have you any right to prevent it? Is there any law that's prohibited?
I am no one. I am no one. I am not a politically influential person.
It's not good. I agree with you. See, it may not be good. It may not be good
okay,
for you and others. But
it
may be good for others.
Can I just bring
Bentham's theory. One man's good is another man's
this was
bad.
not. Let's be honest, producer. Okay, I'm running out of time. All I want to say is that for the longest time, the Supreme Court has been, in recent times certainly, been questioned for not exercising enough moral power, for not restoring the faith of citizens that justice is equal for all. Whether you're a Bilkis Bano or whether you're a Nirbhaya or indeed any woman who is gang raped and sees family members, in this case, being murdered before her eyes. Equality before the law, free of any political bias or partisanship, simply because you have power in a Gandhinagar or in Delhi, that cannot be reason to grant remission. Remission must be purely on the facts of the case and must be equal for all. That's the principle in a way that the Supreme Court has enunciated today and hopefully restored some faith in the rule of law.